today as well. So please join me in welcoming John Wilson. He's president of the immigration law firm GoffWilson, with offices in Manchester, New Hampshire, Boston, Mass, Naples, Florida, and Paris, France. John's practice focuses exclusively on global immigration, both inbound and outbound, public corporations, health organizations, entrepreneurs, and families. John has been selected as one of the best lawyers in America under the immigration law category for more than 20 years and is listed as a super lawyer in the field of immigration law. So thanks for joining us today, John. Anything more you want to tell us about your work with employers before we get going and how you came to focus on immigration law?
Well, Rhoda, thanks so much for that kind introduction. I'm humbled. I always listen to that thinking, is that who I am? Wow.
I see your cape.
Been practicing for about 40 years, the first 10 years of which was mostly litigation. I was a trial attorney. I moved into immigration, business immigration, and never looked back. And it's a passion of mine. It's a passion for everybody in my office. Our entire office is exclusively immigration, 95% business, 5% family as it comes along. But yeah, that's our background. That's what we do. We represent people in all different sectors, employers from universities, energy, finance, engineering, high tech, a lot in the medical field, represent a lot of hospitals, doctors, and nurses, and so forth. And the list goes on, hospitality, agriculture, manufacturing. So all of that. And our practice extends well beyond New Hampshire. We practice, that's probably 30% of our practice, and the rest is across the country.
Wow. Keeps you very busy, I'm sure.
We are swamped, and a big shout out. We have openings. Check our website. I know that's not part of this, but I couldn't resist.
That's okay. And I want you to know KMA helps with recruiting too if you need help. So I couldn't resist that either. So give us a call. We're happy to help. And you know what? We could probably spend the whole hour talking about those 2 private planes that landed in Martha's Vineyard the other day with those poor immigrants that were flown in, but that's not why we're here today. We have a lot of questions because we have a lot of HR people on this call today, on this webinar, that have a lot of questions about immigration, about people that they've hired or can they hire, H-1B, et cetera. So let's just jump right into the first question here. Is there still an H-1B lottery? And if there is, how does it work?
Well, a lot of people don't understand the H-1B. It's reserved for professionals. And by that, we mean a job by its definition that requires a bachelor's degree in a specialty occupation. This is something I just want to throw out to everybody, that we get calls all the time from employers that say, does this work or not work for an H? And we review those. We don't charge for that. So if you ever have any questions as a follow-up, we're happy to speak with you. But, the first thing on an H is to look at the job description. Does the job description support an H-1B? And then the second question is, does the candidate meet those requirements? And so that's the analysis you want to do when you're looking at hiring a new person that hasn't had H-1B status before. And to your question, Rhoda, is there an H-1B lottery? There sure is. It happens in March of each year. It's about 2 weeks, a 2-week window where you apply for the lottery. We like to get going on it in February. We have an ongoing list that we add to, and then we reach out to the employers in February and say, do you still want to do this? And then we register them for the lottery. Some people do this themselves without counsel, and that's fine. We've known those to come back and not be successful. The lift on it on HR time is about 10 or 15 minutes. The cost is under $500 to register. So you want to register during that period of time if selected. And this last year, 75% were not selected. But if selected in the lottery, you have a 90-day window after April 1st to file the H-1B application. And once it's filed, we recommend using premium processing to get a decision within 2 or 3 weeks versus regular processing, which can stretch on for months. But if selected and you file the application and approved, and we know pretty well when we file for the registration whether or not you will be approved, 99% of the time you are. We vet these very carefully. The H would go into effect October 1st of that year. The H can be good for up to 6 years. in 3-year increments. And there's lots of rules if you change the job at a location and things along those lines. Now, Rhoda, I know that later you were going to ask me a question about optional practical training. Let me talk about that now, because this is an excellent source of employees here in the US. So when somebody goes to college, a foreign student, they're an F1 or student status, and when they graduate, they make application for and they get 1 year of work authorization called optional practical training, or OPT. And you can hire that person. There's no immigration requirements other to be sure that they have OPT. And they can work for a year for you. There's no minimum amount they have to be paid. And the only test is whether or not the job follows their degree, follows their education. If they are in a STEM program, an approved STEM program, then at the end of that 1 year, they can file for it and get a 2-year extension of their OPT status. So a total of 3 years. Now, this is important when hiring somebody in OPT, because you want to see when their OPT expires, because you may want to file an H-1B, and chances are, 75% failure rate, you're not going to get it at first, but you want to have as many bites at the apple as you can. So the analysis by HR at the beginning is, when does the OPT expire? One last thing on this point, Rhoda, is that if the OPT expires after April 1st of a given year, but before October 1st, and you're fortunate to have been chosen in the H-1B lottery, so long as you make the application after April 1st, before their OPT expires, continued employment beyond the expiration of the OPT is allowed. It's called gap coverage, up until the time that that person hopefully receives H-1B status October 1st. So a lot of jockeying at the beginning. I don't know, Rhoda, if you're going to ask me about moving an H-1B from one employer to another. If so, would you like me to address that right now?
Sure. Can you do that?
Yeah, sure. So what's happening now is that there aren't enough people to work, right? So
Right.
a lot of moving around of employee,
Wow.
one employer to another. Employers lose employees, but they also gain employees that are trying to better their position. So if you have somebody that you want to hire that's already in H-1B status, then they've already been counted against that numerical limited number of H's, so you don't have to worry about that. As soon as you file an H application for them, they're able to start working for you. So it's a full application. So you have to do a full application, but it's a great way to get somebody in H-1B status. And beyond this conversation, if you are hiring somebody in H-1B, now they're going to want to know when you want to start the green card. And I know, Rhoda, we're going to talk about that later. But it's just important to know that if you find somebody that's in H-1B status and you want to hire them, that's a great way to bring somebody in and have them work for you. And I would say that the majority of the H's we file now are employers hiring from another employer.
Okay, that's good to know. And we have a question here too, John. It says, if someone has a pending perm 11 or I-140 with a priority date, how long can the H-1B be extended?
That's a great question. As one goes through the green card application process, there are basically 3 phases. The first phase, you get a prevailing wage from the Federal Department of Labor. You advertise to be sure that there are no qualified U.S. workers for that position, because a person cannot get a green card if there's a qualified U.S. worker that is willing to accept the job under the terms offered. The Department of Labor, about 14 or 15 months after you start this green card process, if all goes well, will issue something called a labor certificate. Once that labor certificate is issued, the person has a locked-in priority date. That is, they get in line for their green card. You may then file an I-140 application. Once that I-140 is approved, then that candidate can file for H-1B status in 3-year increments beyond a limited 6-year period. So they can be in H-1B status until they're eligible to get their green card. When I talk about priority dates, what I'm referring to is getting in line for a green card. Each country has a limited number, 7% of the total allowed of immigrant visas per year. And if we look at China and India in particular, the backlog is incredible. So if you have somebody coming in from India and you start your green card application process, they'll be knocking on HR doors to say, I want to start, I want to start. Well, the reason they want to start is so that they can get in line, because the line for Indians now is 10 plus years before they're eligible for a green card. So them pushing you folks in the HR community to get the green card started is well-founded, particularly those from India. So I think I answered that question, Rhoda.
Yeah, thank you. Thank you for that. Talking also about H-1B, I've been told that it's almost impossible to terminate someone who's hired on an H-1B visa. Is that true?
Well, that's like a bad rumor. So in the context of immigration law, the employer is in the driver's seat. And that means that the employer may terminate somebody in H-1B status, in green card status, in OPT status, anytime they want. If somebody is in H-1B status and you've applied for them and they have 3 years to work for you and you're into your second year and you terminate them, there is a penalty that might attach, and that is you have to pay for their one-way transportation back to their last country of residence, but you don't have to pay for the family. And secondly, if you do terminate the person, they have a 60-day grace period. They can remain in the US for up to 60 days. And if they find another person, another employer that wants to employ them in H-1B status and they file within that 60 days, then they just stay on and you wouldn't have to face that penalty. So the penalty is one-way transportation back to their country of last residence. And I would say that must be 1 out of 100 employers actually end up paying that because the employee finds other employers that would want to hire them.
Oh, okay. Well, that's good to know. Thank you for that. Great. So what is the difference between an H-1B visa and a green card?
Yeah, so in the immigration world, we like to talk numbers and acronyms. And if I start to do that, just give me that hypothetical kick in the shins here. I can't help myself. So an H-1B is what we call a non-immigrant visa. Immigrant, green card, permanent resident, resident alien, all mean the same thing. It means green card. So if somebody's on a NIV, a temporary visa, then what happens is that they're here for a temporary period of time. And at the end of that, they have to leave the United States. If somebody has a green card, then they're just like US citizens. They can work here in any capacity, doing anything or not at all. So the green card really is what all foreign nationals are striving for. I say all because it's only, that's not accurate. It's only 99%. I speak to many people, foreign nationals who come here and they're here and they're students or just started working. They say, well, I'm only going to be here for a couple of years and then I'm going to go home. And then they always stay. So, they want to, because of their spouse, because of their children. What's nice in the employment arena is that when the primary acquires green card status, so does a spouse and so do children. And children in the immigration world are those under 21 years of age. So there's a big push for the foreign national to get to the green card because they want to have a place for their children to be here in the United States. And this brings to mind the H-4 status. H-4 is the spouse or child or children of somebody in H-1B status. Remember, I was speaking earlier about how they're going to be knocking on the HR door saying, I want to start my green card because I want to get my I-140 approved so that I can get in line for my green card later. It's going to take so long. Well, there's another part of it too, and that is once the employer files for and has approved an I-140, which is 14 to 18 months into the green card process, once they have an approved I-140, then a spouse is eligible to apply for work authorization. The HR world has taught me a few things about keeping the employee happy by keeping the family happy. And if one spouse is home not working, sometimes that causes some issues. So there's lots of reasons why we want to get that I-140 approved. I will say, one issue with somebody securing green card status, and that is, involuntary servitude is well gone in our country, and somebody with a green card has just as much rights as you do as a U.S. citizen to move from one employer to another. Now, the employers say, well, the green card application process costs thousands of dollars. True, it does, and takes some administrative time on usually the part of the HR person. True as well. How do we keep the employee engaged with us after they get their green card? Couple things. If you don't follow through and file for the green card, or at least go through that process, you'll find employees leaving you. So the process itself is a retention tool. The other part of it is there are, as I mentioned, 3 phases to the green card. The first phase, the employer has to pay for, and you can never get contribution from the employee. The other 2 phases, the employer can pay for, or the employee can pay for, or what is normally done is that the employer reaches an agreement with the employee that says, we're going to pay for these costs for you, but once you get your green card, should you leave employment within a period of time, let's say 2 years, then you have to pay us back retroactively for the monies that we invested. And, we find that works as well as a retention tool. So but if somebody does get a green card, they're free to jump.
So that's where that question about sponsorship comes in. Will you sponsor me? Is that what it means about will you sponsor me to get a green card?
That's right. And we spoke earlier of the H-1B, the person coming over from another employer and they want to work for you, you want to hire them. What are they trying to do? Well, they're trying to better themselves financially, but they're also trying to put themselves in a position where they can file for that green card. So they may come to you and say, I want to work for you. You want to hire me. We're agreeable to the wage, but there's just this one thing. Once you file the H-1B, I want you to start the green card process. And, that's when I get calls from HR and says, what does this mean? Well, what it means is that the employee wants to get a place in line. They want that approved I-140. They want to move their immigration case forward so they can stay in the United States. And employers historically have said, and this is common denominator, once you work for us for a year, then we'll consider it because we want to see if it's a good fit. Those days are gone. The employee, it's an employee-driven arrangement at this point, and we'll find employers saying, okay, after 90 days, 180 days, we'll start the green card process for you. We just want to make sure your feet land and you're in a good position. However, we sometimes have people come over and they have very little time left in the 6 years, and you have to make a judgment whether you're going to start the green card application immediately. So there are some concerns there. One last point, Rhoda, on that. If somebody comes to you and they want to work in H-1B status and they've had an I-140 approved with a former employer, you can use that I-140 to file for an H for yourself for an additional 3 years. And secondly, to get a green card, you still have to go through the green card process, but you get to capture the earlier priority date so the person doesn't lose any place in line.
That's why we need attorneys to help us with that.
Yeah, well, I can't comment on that, but I'll just come back and say, it is complicated stuff. And as I know that there are some of my clients out there, and they know that if there are any questions, you can always call. And I think it's good to run these things by an immigration attorney. When we do an intake, and by that, what I mean is that an employer will call us and they'll say, we're thinking about hiring this person. We look at the job description. We look at the resume. We look at the prevailing wage, which we haven't talked about yet. And we call the person up. And then we come back to the employer and we say, you know what? This is not a good hire. You're not going to get 6 months out of this person. They're going to lose status. Or we'll come back and say, this will be a great hire. This is what's involved. And then internally, the employer looks at the candidate, interviews the candidate, and may or may not make them an offer. And I said, we do this as a service to the community. So we just let you know whether or not this can be a go or not. Rhoda, I do want to comment on prevailing wages and what all of that means.
Yeah.
It's important in the H context and the green card context. So the Federal Department of Labor sets what's called the prevailing wage, and it's based upon, number one, the geographic location for the job. So, Manhattan is going to, pay a different rate for the same job than Manchester, New Hampshire.
Yes.
So geographically located, where is the job going to be? What is the job? Okay, is it a chief executive? Is it a software engineer? Is it somebody working in housekeeping? What is the job? And then lastly, what's the experience required for the job? Is it a bachelor's degree? No degree? Is it 3 years experience? Is it 5 years experience? All that wraps into what's called the prevailing wage. And the prevailing wage comes in 4 levels. First level is the introductory level. And the last level, which is level 4, is for those that require a bachelor's plus 5 years of experience or more. And that will drive what that wage is. Now, unfortunately, the Department of Labor comes out with these wages July 1st of each year, and they're high in most categories. You'll look at that and you'll say, we don't pay anything near that. If that happens, doesn't always happen, but if it does happen, then you have alternative wage surveys, such as Radford or Mercer, one of the better ones out there. And you can ask them for a survey for the job in a particular area. And if they're finite enough, in other words, if Mercer comes back and says, well, a software engineer in New Hampshire gets paid X, that will not be accepted because it's too broad. If it says a software engineer in Nashua, New Hampshire gets paid X, then we can use it. So it depends on how narrow it is. Some of it, others, Mercer and Radford are accepted by the Immigration Service and others, but those two universally.
That's good to know. Good to know. Is there any, are there any current limitations on hiring foreign nationals in the U.S.?
Only the numerical limitation for the H-1Bs and for H-2Bs. A lot of employers right now are contacting us regarding H-2Bs. H-2B is also known as the guest worker program. And what it means is that we bring people into the U.S. for a limited duration of up to 9 months. In New Hampshire and the Northeast, they're usually seasonal workers. They may come in and do a job for you. It can't be more than 9 months. If the job is a permanent year-round job, they're not eligible for H-2B. But basically, you have somebody come in, let's talk hospitality, agriculture, the ski industry, whatever it may be. And we say, okay, the person's going to come in for 9 months. We go through this process where we prepare everything, we test the market, and then starting midnight on January 1st, there's a 3-day window where, we hound our attorneys and say, stop your year-end celebration. You have to register us. And then we feverishly go out there and register everybody, and you hope to get chosen. Like the H-1B, there aren't enough H-2Bs out there. There are 66,000 per year, 33,000 released for each 6 months. To give you a sense of it, for last year, there were 33,000 openings for this current season, and there were over 400,000 applicants.
Wow.
So the chance of being chosen isn't good. Doesn't stop people from trying because we're so desperate. I will say that, and for the last year, and I've been doing this a long time, for the first time, we're having employers actually go through green card applications for year-round positions where before they wouldn't consider it, because the green card application, let's suppose you're in hospitality and you want to hire 5 people in housekeeping and you know who they are.
Mm-hmm.
We go through the process for a green card. It takes about 2 years before they're going to be here working for you, but they're willing to do that because they can't get anybody on the H-2B program, or very few, and there's nobody else to work. And I feel and hear your pain out there about nobody being able to work. I started off by saying we have openings. It's at the professional level, but it's at all levels. There just are not enough people to work. So we go through this green card process. It's a long process. It's a couple years. It's not cheap. But at the end, you have workers. And so we started that, a lot of people doing that a couple of years ago, and now we have them coming in and they're working here in green card status, whether it's landscaping, housekeeping, in the hospitality sector, whether it's usually labor intensive, but we're doing a lot of those now.
Well, that's actually one of the questions that came in. Can we request green cards for our H-2B visa employees?
Yeah. So the shorter answer is yes, but of course it's not a short answer. So when you're here on a temporary visa, foreign national such as H-2B, that means temporary. It means the person is here for a limited period of time, and they do not have that so-called immigrant green card, lawful permanent resident. They don't have that intent. So if you enter the country without that intent, can you file a green card application for them? You can. The problem with H-2Bs is they're here for 9 months. The green card process takes a certain length of time. And then, we get to a point, do we send them home and process the application further, or do we try to process it here? When you file a green card application, you file for work authorization, which right now is taking 4 or 5 months. A year ago, it was taking 10 or 12 months. It's terrible. Sometimes they get stuck. We can use congressional assistance. Sometimes that helps. And by the way, the congressional assistance in New Hampshire is excellent. The senators' offices are doing a wonderful job, but there's just so much they can do. Oftentimes they have to go home, and then when they go home, they want to come back in H-2B status, but now they have immigrant intent and they can't. So the short answer, sure. And we do a lot of people in H-2B status. We file green cards for them, but it really requires an analysis of timing and when it's going to happen, and a whole lot of other issues have to be discussed. But it can be done, and we do a lot of it.
Okay, fair enough. So the next question is, what does it mean to have a temporary protected status?
TPS. If somebody's here in temporary protected status, they are work authorized to do any job in any capacity for anybody anywhere in the country. So TPS, temporary protected status, is because the person can't return home. And it could be for a variety of reasons. When Haiti had the earthquake, we created temporary protected status. We have a number of doctors from Syria working in different hospitals. They can't go home. And the list goes on. So if they are here in TPS, they do have work authorization. Sometimes what happens when your folks out there are doing the I-9s for those in TPS status, you say, well, it's expired. Well, you have to go to the Federal Register, and it will say it's extended, and there's a way to mark up your I-9, and we can, of course, assist you with that, but it's a way of marking up so they'll be able to continue to work. But they're great as far as employment authorization. There are no immigration costs. There is nothing that you need to do. They may start working for you in TPS and say, I really like this and you like me and I want to stay here. Well, then we can go through the green card application process. But there's always a but, right? So temporary protected status, if the person entered the country legally and they go into TPS status, we can go through with the green card. If they entered illegally and they still can get TPS status, they can work for you, but moving them to a green card situation is much more difficult. So if a person does enter the country without authorization and now they're eligible for TPS, that's great. We're not going to send them back to Syria. We're not going to send them back to a war-torn. We're not going to send them back to Afghanistan. We're not going to do that. But at the same time, it does limit what their future might be.
Okay, thank you. The next question is, can you give us a general, what's the difference between lawful permanent residence and conditional permanent residence?
Oh, this is great. So, a lot of times, employers come in and they say, well, we want to hire this person, and we start the green card process or the H-1B. And when I vet people, I can ask questions that you folks in HR cannot. I need to know what visas need to be filed. So I will ask them, do you have a spouse or children that require visa sponsorship? And they answer. Now, sometimes what they answer is, no, but I'm about ready to get married. And then my next question is, to a US citizen? And they say, yes. And a big smile, because we don't encourage it. and the Immigration Service is very, very good at what they do, and they can flush out a fake marriage in about a minute. But if it is a genuine marriage to a U.S. citizen, then the green card application process for that is a lot less complicated, a lot faster, and a lot less expensive than an employer going through the green card process. And so what many employers do is that they pay for the green card process if somebody gets married, because they know how much easier it is and how much less money they have to pay. And you're wondering, why am I talking about this when you asked the difference between permanent residence and conditional residence? When somebody marries a U.S. citizen and they get a green card, if they've been married for less than 2 years, at the time they get their green card, it's good for 2 years. It's called conditional residence or conditional permanent residence. What does that mean? That means at the end of the 2 years, the conditional permanent resident and his or her spouse must go back to the Immigration Service and again ask that conditional status be removed and that permanent residence be instated. And by that we mean that they have to prove that the marriage was real. It's a check on the system, and again it's a fairly involved application, but you have to prove that the marriage was real. So if you hire somebody though and they have a green card and it's conditional resident status and it's valid on the day that you hired them, and then it expires a month later, what can the HR community do? Nothing. You can't do anything. The person is entitled to continue working. You do not have a right to terminate the person. You do not have a right to inquire of the person. You don't have any right whatsoever. The question is, at the time of hire, were the documents current? Were they unexpired documents? If the answer is yes, then you're done and you don't have to worry about it anymore. That doesn't mean the foreign national doesn't have to worry about it. And if the document is expired, that foreign national cannot go work for somebody else. But if at the time they hired you, I'm repeating this 3 or 4 times because I had a terrible situation in which an HR person called me one time and said, I just fired somebody because their green card expired. And then I had to say, well, you made a mistake. Bring the person back in, rehire them, give them a bonus, and you'll avoid the lawsuit. So that's what happened. The HR person was chagrined. They didn't know. So yeah.
Wow. And we had a question pop up about this. It says, what if it was a real marriage, but the couple gets divorced?
Yeah, well, unfortunately that happens whether they're foreign nationals or not. And if it's during that 2-year period, then the foreign national may still apply to have the conditions removed, but it's called a self-petition, and the standards and requirements are more difficult or higher. So the foreign national says he still has to prove that they had a legitimate marriage, but again, they will be interviewed in person versus perhaps just a document review. And unfortunately, that happens too often. But yeah, we can still make it happen if the marriage was real. I'm smiling because a few weeks ago, somebody came to my office and they wanted me to file that 751. As I said, about 5% of our work is family work. So I said, so what's going on? Well, the first marriage was fake. At which point I said, I can't help you. You have to look at these cases carefully. But yes, if somebody gets divorced, they're able to go on. If they have their permanent green card, it doesn't matter what their future marital status is.
Oh, wow. Okay, good to know. So let's move on and talk about the I-9 now. This question says, can you give us a general update about the status of it? We know it's under review. The current one expires in October. Yeah, we're all kind of talking about the process because we're still hiring remotely. We're still approving the IDs remotely. What are you hearing? What do you think is going to happen?
Well, you can still review work authorization documents remotely. That expires October 31st. That's been extended, I don't know how many times. The first time it extended, I put a blog out on it, and then it extended again, and now we just say play it again, rinse and repeat. We've done it so many times. I don't know if it'll be extended this time. I think so, because so many employers are now hiring remote. It's not maybe so much because of COVID, but COVID changed how we're going through the hiring process. And I think I hate to say this, but my guess is that they will continue reviewing documents remotely to be authorized. Now, what we are running into, and the HR community is getting into a little bit of a problem, is that when there is a return to work, that work site, then there is the obligation to go through that normal 3-day reviewing the documents in person and completing the I-9. So if you have a return to work policy that kicks in and somebody doesn't necessarily come back, you have to go through that process. If somebody comes back and they come back once a week or once every 3 weeks, you have to do that process within the 3-day time period. And a lot of the HR folks are saying, well, I'll just wait for them to come in and then I'll try to do it. No, the strict rule is that once you lift the work remote option and the person has to come in, then you have to do the I-9 and you have to verify the documents in real time.
Oh boy.
Yeah.
And if they're approving them remotely, do they still have to have like an agent at the remote location?
Not right now.
Not right now. Okay.
Still, if it's permanent remote, I think where all this is going, and now I'm a soothsayer, is that
you were a betting man.
Got my crystal ball right here, Rhoda. I'm looking into my crystal ball. And what I see is that there's going to be a shift, and the shift is going to be, we're going to allow remote hires and we're going to allow the remote review of documents, and this is going to continue in some fashion. It hasn't been codified yet, there's no law on this, but that's where I think it's going. And I think, I just want to comment and say that a lot of employers are E-Verify now. And when E-Verify first came out, I said, don't do it. Many years ago, I said, don't, it's all messed up. It's awful. Don't do it. Now I'm saying do it. I think the program has matured enough that it works pretty darn well. And, you'll find different jurisdictions require it. So if you are a company that's in multiple states and one state has the requirement and another state doesn't have the requirement, and you say, well, in the state that requires it, we'll do it. In the state that doesn't, we won't. What a headache for HR. It's just a lot easier to E-Verify. Take a look at your HR software. Usually there's an icon, you hit the button and it comes back and says you're done, you're E-Verified. Getting on to E-Verify is easy. If your company hasn't done it, you take a tutorial, it takes a couple hours, then you're certified. I recommend it be multiple people for an employer to be certified in case somebody's out on vacation or what have you, because you still have that 3-day window to complete the I-9 and E-Verify. But we promote E-Verify. We think it's a good idea at this point.
Okay, good. Hey, good advice. Thank you. And with everything, in the world going digital these days, is it okay for employers to have their employees' I-9 forms only in digital format?
Yes, it is. However, make sure that the digital format meets the requirements for I-9 completion. And it's not just that you take them and throw them into your digital file. If you have something like Paylocity or whatever it may be, whatever program that you may use, I think that's going to be fine and be sufficient and will meet all the requirements. If you don't, if you're just trying to save them digitally, then there are rules that you have to be aware of. You have to be able to instantly get to them, produce them, show them. A little bit on the I-9 while we're talking about it, Rhoda, is that people are saying, well, I'm not too worried about site visits because, well, it's COVID and forget that. Okay, be concerned that there'll be I-9 site visits. Be concerned that there'll be I-9, H-1B, compliance site visits. These folks that come in are nice people, but they have a job to do, and all should be aware that their job is to find mistakes. And you want to be sure that the person at the front desk, so to speak, knows enough not to let the person into the facility, knows enough to have somebody to call that says Immigration Custom Enforcement or ICE is at the front door and they want to look at I-9s. What do I do? You want to make sure you have those steps in place. So, and that nothing's divulged that doesn't have to be divulged. But I-9 reviews, I-9 audits are as much as ever, as well as H-1Bs. You know, with H-1Bs, you have to have a compliance folder. With green cards, you have to have a public compliance folder, which is open to anybody that walks in from the public that wants to see it. So you want to be sure that all of those are up to snuff and are in good working order.
So you're saying if the USCIS does show up like at your front door and wants to take a look at your online, you don't have to just admit them. You can make them wait while you call your counsel.
Yes, there's a 3-day time period before you have to produce your I-9s, unless they show up with a warrant. If they show up with a warrant, then you have to comply.
Okay.
You know, we give I-9, as you know, Rhoda, we give I-9 workshops and
yes,
so forth. It's important that HR do self I-9 audits periodically. Make sure you're up to speed on these, because if there is an audit by the Immigration Service, or more correctly, ICE, Immigration Custom Enforcement, you know, you have to produce the I-9s in 3 days, and you're not going to be able to fix them. You don't have time to do it. I mean, we've been called in and we're 24/7 for 3 days trying to get employers into shape, but it's just not workable. So always, it's kind of like changing the oil in a car. It's better to do it before the car stops.
You're absolutely right. Yeah, we often do I-9 audits for our clients as well, because it's easy for them to get into a mess. No question about it.
It really is, and it's easy to fix early on, but you know, once ICE knocks on the door, it's hard to fix.
For sure. We have a couple of other questions that have come up here, John. One says, if you hire a foreign student during their first year post-grad work eligibility and you really like them, is there a way you can keep them here? Assume job does have applicants available here.
So if somebody is in optional practical training, or OPT, you may hire them and continue to have them work for you while they're in OPT status, regardless of U.S. workers being available for the job. That's the same for an H visa. You know, it doesn't matter if there's any U.S. workers available for the job. And if you extend the OPT, if it's a STEM oriented job and the person has a STEM degree and the proper application is filed, you can get up to 3 years, as I mentioned earlier, with a STEM OPT extension. So the trick is, if it's a professional job and they're in OPT status, to look at the H-1B and to try to get the H-1B going so that you can extend their employment beyond the date that their OPT expires.
Oh, okay. Then there's a question, do we mail out W-2 tax forms to our H-2B visa workers? And if so, is there something out there that can assist them in their country or here in the U.S.?
Well, I'm not a tax lawyer, so I can't really answer that other than anecdotally, and say that employers do mail the W-2s. Now, I'm not saying that's the right thing to do or not, because it's not my field, but I see that happening all the time. You know, it's interesting, brings to mind you asking that question. You know, employers often ask me in the professional realm, can I employ somebody outside the United States? Well, the Immigration Service only has jurisdiction within the United States. So if you want to have somebody working for you outside of the United States, you're free to do so, subject to the laws of that country. They could be independent contractors, they could be employees, depending on how you set it up. And there are companies out there that will assist you in doing that. But the Immigration Service does not have any jurisdiction outside of the U.S. Further, we talked about the H-1B 6-year limitation. That's time worked in the country. So if somebody goes home for 2 months and then comes back, they still have a full 6 years of work in the U.S.
Ah, okay. That's good to know. Okay, good. So what are the common pitfalls of hiring foreign nationals that employers should be aware of?
The intent of the employee. I say that tongue in cheek because, over 40 years, I've hired a lot of people, and as all HR is, we're kind of surprised by what we find out to be the intent later on. So you want to have a long-term relationship, obviously, with anybody you hire. And I think that knowing what is in front of you in the immigration arena is important before you go down the road of hiring a professional or hiring anybody in the world of immigration. The laws of immigration are set up to protect, as they should be, U.S. workers. A U.S. worker is a citizen, green card holder, asylee, or refugee. They're set up to protect those people. And, that means that it's complicated to get the person work authorization or to get a green card. And the pitfall really is financial exposure to the process, paying the immigration lawyer, paying the immigration service, and your time. That's the pitfall to it. So you want to try to flush it out as much as you can at the front end.
Okay. Got it. We have another questions that come in. I guess it wasn't clear. With the I-9 that's set to expire at the end of October, might they just leave it in place and extend the expiration date at that point if they're not ready to make a decision?
Yeah, so that October 31 date, again, is the date that the leniency ends. So right now you can do remote hires without looking physically at the documents, and that's set to expire October 31. There'll be a notice out there, I'm sure Rhoda, on your site, we do our blog on it.
Yeah.
We'll let you know, but I'm pretty sure it's going to be extended, but we'll see. And then if it is extended, then you can continue to review documents.
Yeah. Well, the form itself says it expires on that date.
Oh, I see. Yeah, well, just ignore that.
Okay.
A lot of them, they've been expired. It's important to use the most recent I-9 form.
Right.
If a new I-9 form comes out and is the one you're supposed to use, and you use the old I-9 form, it's as though you never did an I-9, and they will fine you for that.
Right.
So always be sure you use the one that's currently in circulation. Again, I'm sure Rhoda, on your website, I know on our website, and it's pretty common. If a new one has to be used, we send out a blast to everybody. And I'm not plugging my website on this, but if you go to our website and you look under the I-9 resource section, it has the most current I-9 that you have to use.
Yep, absolutely. You got to stay up on it. Or if you just Google it, for sure, you can find it.
Yeah.
You can always find it, for sure. So you touched on this a little bit earlier, but we have had a couple of questions also about where, the big resignation, or during COVID, a lot of people decided to move and go different places. And sometimes people decided to move to Canada, but keep working for their employers here in the US.
Yeah.
And there were some complexities around that in terms of what that meant for the US employer relative to, did they have to do something with Canada with setting up some sort of accounts in terms of taxes and that kind of thing?
If they go to Canada and they're Canadian, that's one thing. If they go to Canada and they're just a landed immigrant, or there's something else, else entirely. We have what I think the best Canadian immigration attorney. He's located in Toronto, but can answer questions. We refer clients directly to him if you want to have somebody work for you. And it used to be the old NAFTA agreement, North American Free Trade Agreement.
Yeah.
Now it's the U.S. Mexico Canadian Agreement, or USMCA. That's the new agreement. Us in the world of immigration, we're just hoping that after 25 years, there'd be some improvement in that document relative to hiring people from Canada. You want to hire somebody from Canada, there are limited categories under which you can bring the person in. And that's under what we call the TN, or trade national status. So we can bring them in under the TN. They can work for us, but there's very limited. Engineering is good, management consultant is good, nurse is good, but a lot of them are not. Software engineer doesn't even exist, because when they wrote this 25, 30 years ago, that was not a category they were concerned. So they did no upgrading. So I'm venting here a little bit, but the USMCA does not improve upon NAFTA as far as bringing people into the US. You want to place somebody in Canada and they're not Canadian, they have to have work authorization. As far as tax issues involved, again, I have to defer that to somebody else. But it is a concern. You want to make sure that you're complying with whether it's Canada or any other country. If you can get somebody to come in under the USMCA, formerly NAFTA, it's a great fit for the employer. Under NAFTA, under the USMCA, under the TN, there are no minimum payment requirements, wage requirements, as there are under the H-1B or the green card. And you can have it now for 3 years, in some circumstances now limited up to 4 or 5 years, but you get them for a long period of time. They can travel freely back and forth. It's a great visa. The hook to it is that it cannot turn into a green card. And so those people that come in TN will be asking you to apply for an H-1B, so they'll be eligible for a green card. H's can, TNs cannot.
Got it. Okay, good to know. Then there's a question about something called the CO3B authorization. If an employee has a CO3B authorization to work that expires in 2023, what does this mean? And does the employer have to do something about it?
CO3B, I always see that, and it makes me think of Star Wars or something. I don't.
R2D2.
Yeah, there you go. So I just tell the HR world, if you see some sort of designation, just Google it, it'll pop up and tell you what it is. So the CO3B is for somebody that's in OPT status. And that's just what it is. But, interestingly, and I think this goes to another question you were thinking of, and that is, how do we extend work authorization for people? You cannot extend OPT unless it's for STEM OPT. You can get 2-year extension, but you can't get an extension. However, if a person is in a different type of employment authorization, there is a way that upon filing for an extension of the work authorization, that receipt will extend the person's work authorization. It used to be 180 days, now it's 540 days. And there's a way of annotating the I-9 that will allow that person to continue working. A takeaway for the HR community is make sure that you contact somebody who has a work authorization card. We call that EAD, or employment authorization document. Make sure that you set a reminder 6 months before it expires so that you can approach the employee, remind the employee that they're running out of work authorization. Should they file for an extension? Are they eligible for the 540-day extension? You want to all do that in the HR community so that management doesn't come to you and say, why can't this person work? You want to be sure that they have that work authorization. We didn't talk about, I don't know if there's another question pending. I was going to talk about another type of visa, Rhoda.
Yeah, go ahead.
Okay, so there are other visa categories. We've talked about very few. We talked about student F1. We've talked about USMCA, the TN from Canada. Talked about the H-1B, and we talked a little bit about the green card application. There are other visa categories that should be considered, particularly if you have somebody that's really top in their field. There's something called the O visa, and think about standing. If you have somebody that's really lights out, and we can review it and let you know what we think, you might be able to bring them in under an O visa. This is the top 1-2% in that given field in the world. So it's a full-blown application that discusses, this person created this widget, invented this, has that patent, has done X, Y, and Z. We do a lot of that in the medical field for doctors, but we do that in other fields as well. I remember one I had, one of my first ones, which I didn't think was going to get approved, was for somebody from a country in Africa. We'll leave it as that. But they played the bongo drums, the ones you put between your knees.
Yeah.
He was the preeminent bongo drummer in the world. And I said, well, how can you get a visa for that? And I didn't know really, 30 years ago what I was doing. So I filed under that and I got it approved.
Wow.
I sent to the Immigration Service a tape of the guy playing. I'm not sure really. I just envisioned the Immigration Service listening to that. But anyways, so you have somebody though that's really skilled, and O visa might be a possibility. Another visa to consider is something called an E visa. If you have a company commonly held outside the US and you want to transfer somebody in, there's no limit on a number of E's. If you have somebody, for example, from Australia, they're allowed to come in under an E3 visa. An E3 visa is like an H-1B. There are 10,000 of them allowed per year. It's never reached the cap. So if you have somebody from Australia, you can bring them in under that. There are some from Malaysia that can come in under a different visa. So there are a couple countries where if somebody has nationality of that country, we're able to use that. On the green card, remember I told you that India has to wait 10 years to get a green card. Well, I always ask, well, what's the nationality of your spouse? Most of the time it's from India, but sometimes it's not. Sometimes they'll say UK. Well, we can do what's called cross chargeability, and we can pick up on that person's that nationality, and there's no way to come in under that nationality. So some tricks there. We try to get the person here as quickly as possible. One other thing, Rhoda, in the last couple of minutes here, in the green card context, there's something called employment-based 1, 2, and 3, EB1, 2, EB2, EB3. If somebody can come in under an EB1, if they're extraordinary, as somebody might be who comes in under an O, we can go right to green card. We don't even have to check the market to see if there's any qualified U.S. workers. So that's something we review as well. And again, we've done a lot for doctors, but we've done a lot in business as well. So that might be a possibility. So with visa shortage, we have to look outside the box and see what else might be available.
Okay, well, we have one more question here, John. Can someone's OPT be used for a summer internship?
Yes. If they're working and being paid and it's in keeping with their degree, it can be. However, most don't do that because you get that 1 year of OPT and you don't get any more. So if a person in F1 status uses 3 months in the summer, when they graduate, now they only have 9 months left. And so it's not often used. You can get extended OPT. So if somebody comes here and they get a bachelor's degree, they get 1 year of OPT, and then they go back and get their master's degree, they can come out and get another year of OPT. So there's different ways of extending it. And Rhoda, I can't get into what's called curricular practical training and work authorization through just going to school, but there are some other ways like get work authorization.
Well, John, I don't even know how you have all this in your head. My gosh, that's so much information you shared with us today. Do you have any closing comments that you'd like to make or anything you'd like to leave the participants with? Because you've just shared an awful lot of great information with us today. Really terrific. And I'd like to thank the participants with being with us today. And we're going to post this recorded session on kmahr.com late today. Any closing comments, John?
Well, I don't hesitate from looking at foreign nationals. As I said, the passion of our office is to assist people getting into the U.S. on behalf of employers. Our staff is multinational, multilingual, and we'd be happy to work with you and talk with you. And I didn't take the bait, excuse me, Rhoda, of talking about the plane load of people going to Martha's Vineyard. I know that's political, but believe me, I have an opinion, but I'll leave it out.
I'm sure you do. I'm sure. Well, we'll have to have a martini over that one. Thank you so much for being with us today, John. This has been amazing. A great hour. Thank you, participants, for being with us today. Oh, let's see, but we have a couple great article, great. Somebody gave us, I don't know, an article to share. So, all right, never mind. Thank you for participants. Thank you, John. This was a great hour. I hope everyone has a great rest of the week. Enjoy.
Rhoda,
thank you again.
Very much. Bye.
All right, bye-bye all. Oh, and everyone on this call also, we have SHRM certification, so email.